happy to be here. Especially happy to be here at University Law Partners in Orange County, my home. And a little bit quickly about myself. I'm a licensed patent attorney over at Wilson Sonsini. My background is in neuroscience and immunology. So prior to working in law, I completed my master's over at UC San Diego, and then worked in industry down in San Diego for several years. Then I moved over to Wilson Sonsini. If you haven't heard, we're one of the larger law firms in the world.
Oh, sorry, just fixing this. There you go.
Okay. We represent more companies that receive venture financing than any other law firm. And here's some of the statistics. We have offices all across the nation and elsewhere. But most importantly, for the people that I think are watching this talk, is that we are in life science. Life science is our bread and butter. We have great experience with all the top life science venture funds, and a big part of that life science venture raising funds for life science companies is our IP practice, which I'm very proud to be a part of. But here's some of our select clients, and my colleagues, like myself, all have strong technical backgrounds in the industries that we advise on. So, with that, let's get into the substance of what we're talking about today, and that is, the inventorship and ownership of patent applications and patents. So very quickly, what is a patent? It's a government-granted right. It gives you the right to exclude others from making, using, offering, selling, and importing into the United States the invention, quote unquote invention. Patents have a term, the 20 years from the early state. This is your kind of temporary monopoly for an exchange that the government gives us in exchange for our teachings to society. These teachings are included in the patent. And then the most important aspect here, the most important part of your patent, the quote unquote invention, is what's described in the claims. And the claims are what really going to drive this conversation about inventorship and then ownership. And before we dive into the next slide, I just want to note, while we are going to have Q&A at the end, please feel free to, anyone in the audience, raise your hand, stop me. I think we're going to have time to talk about things, so go ahead. So, as I mentioned, the claims, most important part. Claims are usually found at the end of a patent application, and they're numbered 1, 2, 3, 4, maybe up to 100. This application only has 4. So, why are these claims so important? Again, these claims are what define what the invention is. These claims define what other people cannot do. And what these claims also are important for is the claims are what determine who the inventors are. So per the United States Manual for Patent Examining, an inventor must contribute to the conception of the invention. So as we just discussed, the invention, i.e. the claims, and a person to be an inventor must have conceived of one of those claims. Taking a step further, the inventor is not required to reduce the invention to practice. So practically speaking, what does this mean? What does this all mean? If going back to kind of the claims, if we look at claim 1, that compound, one of those 3 inventors from the previous slides conceived of the idea that, hey, this, and I'll tell you right now, this compound's actually, it's a specific enantiomer. So the person that contemplated or synthesized this compound, he is an inventor. He conceived of this compound. Now let's look at like claim 3, for instance. A method of treating a subject suffering from one of these diseases comprising administering the compound. Perhaps the first guy, let's for example, I think Niels, he thought of this compound, and then between Kate and Johan, they decided, oh, this compound could work for sickle cell. That's how we're having multiple people on this one patent. Hopping back, that last note, an inventive entity, so that all the inventors for a particular application is based on some contribution to the conception of at least one of these claims. Just need one. Now, something I see all the time when I'm dealing, especially with someone that came out of academia or with someone who's in academia, is this conception of authorship, and they're very, very different. This was a paper that I was I contributed to back in my research days, and I'll do the homework, the patent lawyer homework for you guys. The claim that would come out of a patent application based on this paper would look something like that claim, a method of promoting axon growth. And I'll admit to the world right now, I would not be an inventor on that patent. It was not my idea that silence conditionally into knocking out Rick would lead into the axon regeneration. I'm not going to say it on the record who exactly his idea I think it was, but between Edmund and Yimin, it was most likely one of their ideas. Now, I contributed to certain aspects of our discoveries, but I was not approached for any inventorship, nor do I think I would have been, correct legally an inventor on that claim. So this is just a practical example of kind of the differences of when we get into inventorship versus authorship. And we're about to kind of hop into what this all means specifically with respect to ownership. Because as soon as we start adding inventors, then there's going to be, every inventor might have a different situation, a different obligation of assignment that's going to bring in ownership issues with the patent issue.
Maysam, one question. What if you are involved in doing some experiments, key experiments, be part of these, reducing it to actual, practice?
Great question.
Could you be an inventor at that?
Great question. So the question was, if you are working on the key experiments that reduce the invention to practice, can you be included as an inventor? So that's a great question, Milan. And the knee-jerk response is, I'm going to have to revert you back to the law, which says they need to conceive of the idea. Now, we will get into situations of how the person that reduces the thing to practice can end up on this patent application. So let's take this example. These aren't real claims, just kind of put them together. And I want to illustrate 2 points here. Point number one is the point we just talked about with what happens to the people that kind of didn't think of the main idea and just kind of reduce it to practice. And then point number two, the fact that through examination, the claims can change in a patent application. So idea number one, or claim number one, we can kind of read through the details, but it's the last kind of key is what I want to direct your attention to. When the surface has a roughness of less than or equal to 2 microns. So in this case, we could say the main let's just hypothetical, the main inventor, his idea was, okay, if we make this device with a very smooth surface, it's going to get us really good results. And then he goes to his PhD students, postdocs, and he says, all right, let's kind of reduce this to practice. Let's work on it. I figured out, like the PI can say, I figured out a way we can polish, the surface and get it down to 2 microns or less. Let's work on it. Then maybe postdoc number one says, hey, I found some coatings we can apply, and that coating will also work too. PhD student number one comes in and says, oh, I figured out how to put a liquid layer. We could just put a liquid layer on the top surface, and that gives us the smooth surface that we need. The first PI, let's say he didn't contemplate the coating or the liquid layer. You talk with your patent attorney, get these claims on your file. All 3 people are going to be inventors, because the first guy did not conceive of that claim, the liquid layer claim, and it wasn't exactly through the reduction of practice that postdoc or PhD student number one became an inventor, but because he was in that position because he was intimate with the idea and the technology, he thought of this idea. He conceived of the idea of applying a liquid layer. Now, let's say through examination, the prior art, the examiner says, oh, people have done this with polishing, people have done this with coating, but no one's done it with a liquid layer. So I'll give you, if you put the liquid layer into the top claim, we'll give you the liquid layer claim. Now, what should be happening is the patent lawyer should be reassessing to see, okay, if this was, let's say this is the only claim left. back into our scenario of person 1 did claims 1 and 2, person 2 did claim 3, and then someone else did claim 4. Now, person number 2 shouldn't even be on the patent anymore. That's what should happen. Practically speaking, when we get to assignments, we'll talk about how, is it fatal to not remember to take someone off? Not as fatal as forgetting to put someone on that should be on there. So just want to recap on this inventorship concept before jumping over to ownership. Again, the person that conceived of at least one of the claims. Reduction of practice by itself isn't enough, but typically, and we'll revisit this, the people that reduce these things to practice are in positions to conceive of more ideas, and because of prior art, sometimes those more ideas end up becoming very critical for the overall patent. Inventorship of a pending application can be corrected. There was a slight note on the last slide. Because these claims can change, the government has allowed us to change the inventorship. Once it gets issued, it's a different story. So we need to be vigilant on this. And then incorrect inventorship can lead to a loss of rights. There's an example at the very end of this talk we'll get to where there's inventorship was wrong and there's a lawsuit now. So it can be bad. And to make sure to make the worst case scenario of a lawsuit not as bad, I want to just remind us all to always take copious notes when you're conceiving of your ideas or really talking to the rest of the lab about what you're thinking. I'll stop very quickly. Is there any current questions on anyone in the audience? Serena, did you want to maybe pull up the chat very quickly?
Yep. Let's see. I don't.
Yep. All right. I think we're good.
Okay. Yep.
Yep. I think. Here we go. Okay. At the very. All right. That's what's better. So, ownership. Obviously, we want to own the patents that we purport that we own. But what's very more specifically, in order to actually sue someone for infringing your patent, you need to have full rights to actually practice the patent yourself and enforce the patent. Now, the easiest way to answer those two questions is to just outright own the patent. That's why it's very important to understand how do we come about to own these patents. Now, the very first step in assessing ownership now is really inventorship. Commonly, almost in all cases, ownership is defined by some sort of contract, and we'll get into these types of contracts. But on default, and even with a contract, the first analysis step is determining the ownership, the inventorship. So as I said, first step is the inventorship. So without any contract whatsoever, if you work for yourself and you conceived of an idea, you want to write a patent application, you have some money, no one else is paying you, you have some money, you go to a patent attorney and say, hey, thought of this idea, make a patent for me, here's some money, and the inventor, patent attorney writes it, you review it, he says, oh, is there any other inventors? And you say, nope, just me. Put your name on it, and you own the patent. You are the owner. As long as you have no obligations to assign your rights to anyone, you are the owner. Now, at the most basic level, when it comes to these, especially with startups, investors want to see that the company owns the patent. So typically what people do is, then what an inventor who's starting a company will do is assign their rights to the IP to the company. What do these assignments really mean? What do they look like? I've borrowed some kind of boilerplate language from some of our agreements, and really it says that anything that anything that's in this patent, any invention, and any patents related to this patent are going to the company or the assignee, whoever is on the other end of this agreement. Now, the reason now this was a situation where there was no contracts, just someone you're working for yourself. More often than not, especially to fund the conception of an idea, you're usually employed or getting paid by someone. And typically in employment contracts, there will be language like the language that we're looking at right now. So here's an excerpt from the University of Wisconsin's IP policy that is part of their employment. Now, most of the time, without looking through the actual legalese, you can kind of assume if you're doing it on someone else's time, on someone else's dime, then it's probably not. You probably have some sort of obligation to assign your rights. In this case, University of Wisconsin saying that you must assign if the invention is funded by one of our grants or a government grant that was given to the school. This is actually probably pretty favorable, pretty favorable, pretty generous to the inventor or the employee. Conversely, here's the University of California, and there's an added little. I emphasized it, but within the course or scope of my university employment, while employed by the university, in addition to the kind of the time, dime provisions. Looking a little bit further, anyone, they kind of throw in that second bullet point there that even visiting scientists, anyone who's just using the facilities, have to agree to these same terms. So the most important thing to consider here. Yeah,
so for those examples, it's not uncommon for stuff to work with academicians, people working in institutions such as these. They've signed agreements that have this type of language. What is the best course of action to find out what could be the language in their contract? How to appropriately engage to avoid some of these issues. What's been the best tactic you've recommended to try to figure some of these things out before it's an issue?
Right. Well, we definitely have to great instincts, and great question. Definitely want to tackle. We have to tackle these issues before you start working or before you start, disclosing some of your confidential information. Now, when you're working with a university, especially even private universities, these policies will be online, but you should be first of all talking to the actual collaborator, and sometimes they don't even know what these policies
Normally
are.
the case, I would say they don't know what.
And to the extent possible, and I know that the guys downstairs will appreciate this, you should be transparent, not fully transparent, but as transparent as it makes sense with the tech transfer licensing officer, because they will definitely know what exactly is going on. And really, as kind of I've glossed over this last bullet point, but I'm glad you brought this up. All of these universities will provide some sort of scenario or mechanism to where the collaborator, the PI, is free to be in an engagement where the IP might go to somewhere else. A lot of times it's maybe a situation where you're kind of, if the company is providing the funds, the grant, the research grant, or the facilities, or maybe the proprietary information, the last one wouldn't necessarily always result in full ownership by the company, but it'll help. And so really, to answer your question, you need to work with the collaborator and the university to make sure we're in a scenario like that third bullet point. That's really what you have to do that, or else you're going to get into a situation where the collaborator, the PI, he doesn't know anything, and he says, "Oh, here, I'll fill out my assignment form. Company owns it," and then it becomes a blockbuster drug, and then UCI comes after you and says, "Hey, he was supposed to assign this to us. We actually you owe us like half of the $1 billion you just made over the past 10 years." That's not a good, like you said, we want to avoid that situation.
It would seem to be 100% precedent if they sign something to their employer, regardless of what they signed to somebody else. That's not.
That's right.
The the top level agreement.
That's
that
right.
will supersede.
Exactly. In my hypothetical, that the assignment he signed to you is null and void.
Because they,
Yeah.
people sign agreements with boilerplate consulting agreements
Right,
that will have
right.
language about this, and then make the company feel like, hey, we're good to go.
Exactly.
But that's not the case with one of these. This type of language in a different contract that we didn't know about. So
Exactly.
bring into this for each institution because it's probably varied by institution.
Right. We just saw it.
And it says tech transfer. If you just email the contact and say, hey, I'm looking to work with a physician or a clinician, what's your policy, or let's talk about.
They'll at least send you a link. They'll at least send you a link so you can check it out yourself, or retain an attorney and look into it.
Thanks.
So, and this is a great kind of discussion, because the next kind of sets of slides, I want to walk through different scenarios, different kind of relationships that kind of call into different outcomes. So here's an example of how the company A can become a sole owner of any IP resulting from the relationship. And I do have to throw out that none of these terms are what would constitute as legal advice here. These are just examples of how situations play out. But if you define intellectual property rights as any patent, that just any patent, and then you throw in, say, okay, project IP means intellectual property rights created throughout the study. Attach the protocol, say this is the protocol in Exhibit A is the study, and then you just define any project IP is going to be owned by party B instead. And taking it further, you need that last bullet point, party A hereby assigns to company or party B all of the right, title, and interest it has in project IP. So very simple. This is we'll start simple. And in this case, obviously, party B is going to own all the IP. Now, when this is our ideal situation. When is this practically going to occur? Usually, if party B is who's funding the entire project. This is likely like a fee for service type sort of agreement. But it's everything's kind of relative in these negotiations. But this is an example of how this scenario would play out. Conversely, to click this over. Okay. Here's a situation, really a situation that is going to be a little bit more collaborative as opposed to just here's some money, here's some cells, test them for me. Where we might end up as joint owners. Inventions, again, any new invention created during the study. Study is the protocol. Inventorship will be determined in accordance with U.S. patent laws, very common contract term. This is everything we just kind of went over with that conception versus reduction to practice. And then any invention invented by one or more employees of company A and by one or more of company B shall be jointly owned. Pretty simple. And usually these types of agreements will provide for, there is a cross, to the extent we get an issued patent out of this, there'll be a cross non-exclusive license, gives both parties FTO. And then perhaps, this is just an example, you can provide for an exclusive negotiating period or an exclusive option to negotiate a full license. And typically, if you're in a position where now let's think about that reduction of practice that we were talking about. If you're kind of in a situation like what we're describing, and you're not conceiving of any of the kind of new ideas, this is a situation, Lad, where you would perhaps want the study or this agreement to provide that you have some of your personnel with hands-on at the ground level, so that maybe it's one of your guys that thinks of, the liquid layer. If the overall project is let's get 2 microns or less, I want one of my guys to be in a position to where he discovers the liquid layer, so that ends up as a claim, and we can say, hey, this is at least a joint. If we don't have anyone, and we're going with U.S. inventorship or U.S. patent laws, we might have no one on. And then those licensing negotiations are going to look a lot different. Any questions on any of this so far? So here, I just we can go on and on about licenses, but I wanted to just provide kind of how would a license, especially when arising from the last scenario, play out into the overall concept of ownership. Because as we talk about ownership, you need the right to practice the IP and enforce the IP in order to even sue anyone. So again, patent rights, very similar, but here we have this field. You might do a field provision. Most licenses have it, some don't. This would give the person that owns the patent, if they want to start dividing it into fields, you can start have multiple licensees collect more revenue. It will kind of complicate what happens if any one of those guys wants to enforce it, as we'll get into. But if fields happen, and company A hereby grants a license to company B to practice the rights. That's what the license will look like. And what I want to kind of clear up is that line right there only satisfies one of the two provisions that we needed for being able to sue someone. That line, here's the license to practice the patent rights, gives us the right to practice the claims, not necessarily to enforce. What we need for enforcement is all of the people that have the substantial rights. So in this case, the owner and the licensee need to join in on the lawsuit. So these license provisions, these license contracts will have something at the very end under like infringement or enforcement contract language that looks something like what I have up on the screen, which is we agree to join in on any lawsuit you want to start on your dime, and you have to agree to join any lawsuit we want to start again on your dime. Which I think this one did say, well, if we join you, if we make you join ours, we'll pay for it. But and that whole relationship gets a little bit more complicated when you start licensing out to multiple fields. That's kind of what I was getting at with the fields. But this is how you kind of close the loop if you're in a situation like this, where you end with only half ownership or maybe no ownership, and you still want the rights. You're telling investors, hey, I'm working with this other company. We're coming out with this cool technology. You need to be able to at least get to these top two things. That's what we need to get to get funded. And again, ownership is the easiest way to get through that. But if it comes down to it, we might need to do something like a license. So before we get over to the dispute, the primary thing I wanted to get across to everyone based on these last three slides was really just be mindful of who you're working with, who you're talking to, who you're collaborating with, and make sure that you understand what that person's obligations of assignment are. So here's an example of when an ownership dispute can arise. This case, the complaint's public. You can kind of Google this phrase and look it up. And really, what kind of the cliff notes of what happened here was there was a company that developed a viral vector for gene therapy, and another company said, hey, we're looking to cure a particular disease, and we think a viral vector with our transgene might work very, very nicely. Let's start talking. And they actually had a couple agreements executed, at least a confidential disclosure agreement and a material transfer agreement. Somewhere down the line, they weren't able to negotiate a license, and one of the companies went and filed a patent application. That company ended up getting an issued patent, and I believe they filed an IPO and had a very successful IPO. And when this company became so successful, some of the directors at the first company said, hey, they're kind of using that vector that we showed them under CDA. What's going on here? And now they're in a dispute. It was active as recently as December. Today, when I was looking into it, it could have settled, but don't quote me on that. but this is a case that I'm actually kind of watching. So I'll provide everyone an update when it comes. But this is an example of people didn't contemplate. You never think about, okay, a bad actor, but if you think about some of the stuff we went over today, and it just becomes part of the inherent way of how you conduct your business, you'll be more so protected from bad actors or just simple, miscommunications. Moral, overall point here is, if these, had one of these companies kind of contemplated the nature of these discussions or what was being disclosed, then they would have been better. They were thinking about it beforehand. Perhaps they wouldn't have disclosed some of the things that they disclosed without the proper, protections in place, or just the nature of the collaborations would have been a little bit different, such that the first people didn't put themselves at risk. Now, and as I said, getting it right is very, very important, because what the first company, the people that instigate the lawsuit, they're asking for not just co-ownership, at least co-ownership of the patent at issue, but also disgorgement of all the money, all the funds that the second company that filed their IPO raised. So, that's a killer. That could be a killer.
So, obviously, having your house in order, protecting your stuff is critical, but having discussions, these types of things are sometimes necessary. If you're on the receiving end of that, you don't want to be tainted, so to speak, by hearing about other people's ideas, which then limits your ability to act. What are the right kind of legal boundaries to set up to allow your team to still be creative and potentially think of the same idea somebody else has, but have a firewall such that you can actually do that and you can have a legal defense that this doesn't apply because you're not a bad actor. It just so happened that we had the same idea you had, but I didn't, we didn't share that information.
Right. Awesome question. That's an awesome question. Multiple ways to address that overall issue, and just kind of depending on the specifics. One way would be, kind of an overarching thing that I always advise my clients is, let's file, let's whatever, without taking any information that you've gotten from them. Hopefully this conversation is happening before you've even talked to them, so that it's impossible to say, hey, this is any of theirs. Let's file a provisional patent application on what our ideas are. And then when we get to the actual agreement, we provide for background IP. Hey, this is ours. We already filed this before you told us anything.
Yeah.
And this is, we want to collaborate, but let's be clear. This was our idea. And then if they, happen to read it and be like, oh, well, we thought of this too, then you guys can kind of more clearly have that discussion. Another way, kind of a different scenario, but same type of issues. You'll see clauses in these contracts that are more, they can have different names, but my favorite name is a residual clause. So that refers to the residual knowledge that you have just based on talking to someone. And we can define some of these contracts will define right there who owns the residual, or it just clearly says any residual knowledge is owned by the recipient of the confidential information, or vice versa. But that'd be a tough one to pull. And you can also, another way of tackling that is providing, who owns any improvements. You can define what an improvement is, and kind of, say who owns. A lot of times improvement clauses might again incorporate the U.S. patent law type lingo, but the more clear the better.
So Maysam, in this case, what if this company who's doing the IPO say that the initial conversation we had, let's say 8 years ago, was version 1. The product is in the market is version 10, is significantly different from the initial conception. Do they have the advantage to basically continue their practice? It doesn't really matter, so long as using some elements from the original idea, still they are obligated.
Great question. So it's going to come down to what information did they act on, and how did they get that information? So I mean, the easiest way out of a confidential agreement, a confidential disclosure agreement, is if you can prove that the information that was given to you confidentially is published somewhere or became published. As soon as it gets published, you're off the hook, you know. So that could have been one argument from the company that did the IPO. It's like, oh, you know, this published, the university guy, the guy that founded the first company, his university publication published in December. You know, we don't really need them anymore. We don't owe them anything anymore, right? So that's one scenario. And it's these things it goes back to kind of that last bullet point, take notes, because if you look at the complaint, all it is referring to very specific meetings, specific times, and saying, this is what was said, this is what we put on the projector, you know, this is what they said. And then it's a costly battle to prove what information did the second guys have before. In this case, they didn't have any background IP before, so that hurts them. Had they had a background, you know, just a provisional patent that says, oh, a virus vector that doesn't kill you, that has our transgene for our disease, had they put that before they ever talked to the first company, that's going to help their case to say, hey, we thought, maybe we didn't know exactly how it was going to work, but we thought of this idea and we thought that it would work. We talked to these guys about how to make it work, and lo and behold, it works. You know, so that's a kind of a way. It's not a slam dunk win, but that's how you would kind of tackle that issue if you're the other guy, the bigger guy.
Real quick on the notes, taking notes thing. What's the best way to kind of document that without like coming across as a jerk, potentially in a situation like you can say, "Hey, I took 10-page notes. Here they are," to document it. But the receiving party may question kind of why you're doing that. Does that make sense?
It does make sense. It does make sense. And
like, if I just take notes in my book and sign it, or just I'm gonna date the page, I don't know if that would be, you know,
so there's just different degrees, and it's tough to say. It's tough to use the word sufficient in these legal cases.
Right. Depends, right?
Right. It always depends. But you know, of course, if you were to like draft up some minutes and then circulate it to everyone, and then have an email that says, okay, I'm assuming if you don't reply to all, I'm assuming that you agree with the minutes. You know, that's something you would save, right? And if you write there in the minutes, oh, you know, JS said X, Y, you know, and no one's, you know, that's one way. But scribbling it in your notebook, dropping a little date, and even if it's not contested, is better than not.
Better than nothing.
Right? It's better than not.
Thanks.
Yeah, of course. So, ownership takeaways. You need the right to enforce any patent rights you purport to have. No sophisticated investor will fund you if you're not able to demonstrate this. So again, easiest way is to just own it. But as we kind of lightly talked about, there are things like licenses. Understand your own obligations to assign your IP rights. We kind of skipped over this one, guys. We were just talking about understanding your collaborators' obligations to assign, but make sure you understand your own. Especially if you haven't, you know, if you're not employed, if you're not self-employed, you're just, if you are employed by someone else and you're kind of working on your side hustle, make sure you have looked at, you know, kind of those provisions that we looked at from Wisconsin and the University of California. Make sure you look at your companies. Make sure they don't try to sneak something like, you know, anything that is ancillary to the work that you're doing at your office, because chances are your side hustle is probably related to what you're doing in some shape or form. But understanding those provisions, the actual legalese of those provisions is very important. And then, as we've been saying, taking care with in whom you're collaborating with. And lastly, kind of going back to that reduction in practice concept, think about how this is all, as you're going into collaborations, think about how it's practically going to play out, what you're contributing, what you're expecting the other side to contribute. And then that will help you kind of structure the teams, the work, to make sure that, you know, if you're not kind of conceiving to the idea, at least you're putting your people in the right spot. I believe that's just the last one, kind of hammering it home, just get it right. You know, a lot of kind of what we talked about, everything that we've talked about, it's not the responsibility of the US Patent Office to judge these things. They're just kind of taking your word for it, taking the inventor's word for it. There's a form for all inventors called the declaration where it says, I've read the patent and yes, I invented this. The inventor's supposed to sign that form, and the USPTO just kind of takes it. These things don't become an issue until the product that we're talking about becomes a really big deal, and at that point, it's a really big issue. So it's really important to get it right. And there are ways to fix the inventorship of an issued patent, but it's a much higher level of scrutiny. And if they ever find out that there's even a hint you're just trying to kind of, I didn't want to put the UCI guy because I didn't want UCI to own it. And if you have a wildly successful, let's say you got away with it for 15 years, your patent's gonna get invalidated for those last 5 years, and UCI is a good cause of action against you. So get it right. Above all else, it's important to have our inventorship, have our ownership, obviously, but we need to get it right at the end of the day. And that is the rest of the talk. I think we're a little bit early, but I'm happy to stay and keep answering questions. I think these have been great questions so far.
We do have a question from the chat from Paul Stein. He says, please comment on how big corporations infringe on a patent and then use the PTAB to justify their actions by working to invalidate the patent.
Okay, great. A little ancillary to the topics we've covered, but close. So prior to 2012, the way this all works is you see someone's infringing your patent, you send them a letter saying stop doing what you're doing. They don't respond, and then you file a complaint in federal court saying, hey, they're infringing my patent. Then those guys say, oh, your patent in federal court. They say, oh, your patent's bogus. Your patent's invalid. And then you fight it out. You argue it out in front of a judge in federal court. Sometimes it could go to a jury of lay people that aren't necessarily in the technical field that's covered by the patent. You might have a judge. You'll most likely have a judge that has no background in the technical field of what the patent's about. And because it's federal court, there's a lot of procedure. The procedures that lawyers go to law school for 3 years to learn how to comply with. And because of those procedures, it's a very expensive process. It's very even to defend, very expensive, at least $10 million. So in 2012, they made they gave the PTAB some more authority, some more rights, including what's called an inter partes review. An inter partes review is going back to those federal courts. There's maybe 5 or so different. There's a number of different reasons you can use to invalidate a patent, to ranging from, hey, someone's done this before, to, hey, your inventorship is wrong. For these inter partes reviews, they're limited to situations where, hey, someone has done this before. But within that realm, it's a much more efficient way of invalidating a patent. Typically, you're working with judges who have some sort of technical backgrounds. You're not going to get a jury. And because of the expedited procedures, it's going to cost a lot less, typically in the range of like 800,000 to upwards like maybe 5 million if it's a very, very complicated one. And you can look this up. You can look up the statistics, but the way it works is you file a petition and say, hey, judges, consider invalidating this patent. And then they either say yes or no. If they say yes, I don't recall off the top of my head, but the percentage of getting at least one claim knocked out is I believe more than 50%, based on the statistics. So there are all these different milestones with those IPRs, and typically each milestone just completely changes the dynamic of like the settlement negotiations and things of that nature. Like, for example, if the petition doesn't get instituted, then the patent owner is not going to be, motivated to settle. Whereas if the petition does, if the IPR does get instituted, then the guys think, oh shoot, 50% chance of losing at least one of these claims. Maybe I should come to the table. So kind of long-winded, but that's, it was an open-ended question, and I hope that kind of gave you some good information, Paul. Thank you for the question.
Ownership with consultants. So similar discussion with physicians, but that's going to be divided by one contract they sign. An individual consultant could have 5, 10, 20 agreements. Certainly you can take them at their word that they do have the right to assign to you work on your contract, but they sign somebody else's agreement without reading it, and it's broad and broader than they should sign. Is that a realistic concern to worry about, or is it a risk you just have to take as a startup?
No, it's a very realistic concern. Very great, another great question, and a very realistic concern. And the answer is you got to apply everything the concepts we just talked about to that situation. You need to ask the consultant, are you currently under any obligation to assign any of your IP rights? And that could be its own contract that you make them certify that and chances are all those contracts are going to be confidential. So right. Perhaps you're not going to have the right to see those contracts, right. But you can ask them that to certify if they are under any obligations to assign. And that's not the golden fleece, but it'll offer some sort of protections.
We have a couple more questions in the chat.
Great.
We'll have time for these last two. One question from Carrie. She says, "What if I have an idea for a medical product that needed to assign a complete formula? Will I get the patent?" And then Joe asked, "Is there a way to look into the content of a provision?"
Okay, let's take the second question first. Low hanging fruit. Unless you own it, no. Unless you own it or are given the patent by the owner, no. And provisional patent applications are technically confidential information of the owner. And if the provisional is converted to a non-provisional, it will publish when that non-provisional publishes. So that's the easy one. First question was, if I've designed a pharmaceutical and I need to get it formulated, will the formulators be inventors? Was that the question? Essentially. So
they have an idea for a medical product that needs scientists.
Okay. So the question is, there are several layers to unpacking. Layer number one, is the pharmaceutical composition the subject of a patent? Is it something you're pulling from 20 years ago that you're reformulating, or is this kind of is this a novel? Is it published? Is the API itself actually published? That's going to help. If the answer is no, it's not published, it's just a proprietary API, then that's going to help your arguments in saying, hey, we own all of it. Now, typically, as we've kind of discussed, if it's a fee-for-service type model, you are in a good position to negotiate full ownership rights of any IP. Sometimes with a formulation type company, they might provide that if in the course of providing your services, we discover some sort of new technique that helps our formulation machines or our processes, we get that. But anything that happened, that would block like your product or your practice, we're going to give you an automatic, either you own it, or if we invented it, we'll give you an automatic license, paid up license. One of those. So that's typically, and in Carrie, I'd be happy to follow up on the specifics of your situation anytime you want. My email's right there, also on LinkedIn. But I hope that did answer the question for now at least.
You said thank you.
Great.
I think we have one more question from Paul. He says, when one is an original sole owner of a patent and later assigns to a company, when that is done, must the USPTO be informed? Would there be a change to the patent?
there was a second bullet point that I did not say, but I think it answers Paul's second question there, which is assignment documents do not need to be publicly reported to be effective. So I think the simple answer to your question there, Paul, is no. You don't have to notify the USPTO of a change of hands. It's one of those things that it comes up. It's really self-policed, and it comes up when there's an issue.
So if those aren't publicly reported, makes sense. Let's say you're doing diligence on your idea, you find a patent from some random person and you want to find out if they have license anywhere. Are there ways to figure those things out, or is it up to just, random disclosure that happened that may not have been?
It's for a license agreement. It's going to be tough.
Right.
It's going to be tough. Like if it's a public company,
Yeah.
you can go to their quarterly reports.
Yeah.
And they're going to have to report any transaction that's material to their business or material to technology. If it's a private company, sometimes they'll press release announce these things. They won't maybe say license. They'll say, oh, we're collaborating with this university or collaborating with this company. So those are clues. To answer your question, it's really, you got to look for clues as opposed to black and white.